Welcome to the lesson on actual occupation under UK Adverse Possession Law, post the Land Registration Act 2002. As usual, the learning materials for this topic can be found in the description, below the video, in order of appearance. The issue of acquiring land through long possession is governed by the modern law of adverse possession, now regulated by the Land Registration Act, LRA, 2002. The Act reformed the law by narrowing the circumstances under which adverse possessors may acquire title to land. It also restricted the scope of overriding interests, which had previously been more generously recognized under the LRA 1925. Barbara Bogusz argues that as a result, it became significantly harder for adverse occupiers to establish ownership of land they occupy. The Act treats registered and unregistered land differently. For registered land, Schedule 6 of the LRA 2002 sets out the procedure, whereby an adverse possessor may apply to be registered as the legal owner after at least 10 years of uninterrupted possession. Meeting procedural requirements under Schedule 6, Paragraph 2, entitles the applicant to seek registration, though the burden of proof rests on the occupier. In contrast, unregistered land remains subject to earlier rules, with ownership potentially extinguished by long possession. A central requirement under the LRA 2002 is that of actual occupation. As Chris Bevan correctly observes, while the legislation retains this term, much like the 1925 Act, it provides no definition. The LRA 1925 had been understood as requiring physical presence on the land. Similarly, under the 2002 Act, a claimant must demonstrate actual occupation for their interest to override a registered disposition. In practice, judicial interpretation has been necessary to clarify the scope of this concept. Courts have sought to refine the meaning of actual occupation through a series of significant cases. In Thompson v. Foy, Judge Lewison described actual occupation as a question of fact, and importantly, linked it to the claimant's intention. He held that absence from a property does not mean that a claimant is no longer in actual occupation unless accompanied by an intention never to return. While this approach acknowledged that temporary absence need not end occupation, it also introduced considerable uncertainty, since intention is difficult to measure. It has been argued that this undermined predictability and risked unfairness, as the outcome of Thompson itself demonstrated. The Court of Appeal expanded the doctrine further in Link Lending v. Bustard, where the claimant had been absent from her property due to involuntary hospitalization. The court emphasized her continuing intention to return, holding that she remained in actual occupation. This decision attracted criticism because it appeared driven by judicial sympathy, raising concerns about whether similarly favorable findings would be made for less sympathetic claimants. Furthermore, Lucy Webb argues that the case conflicted with the LRA 2002's objective of ensuring that rights are clear and discoverable, thereby risking an increase in hidden overriding interests. Earlier case law under the LRA 1925, including Williams and Glyn's Bank v. Boland, 1981, treated the expression actual occupation in its narrow and ordinary sense. However, ever since the decision in Abbey National Building Society v. Cann, 1991, the court had required evidence of some degree of permanence and continuity. While Link Lending built on this by recognizing involuntary absence and intention as sufficient, critics maintain that it complicated the law Parliament has sought to simplify. The decision has been criticized by Simon Gardner for going against the intentions of the drafters of the 2002 Act. Lucy Webb noted further that by departing from the more objective approach of Boland, the decision potentially broadened the range of overriding interests. Barbara Bogusz, however, has defended the ruling as consistent with equity's flexibility and as a necessary judicial response to the statutory ambiguity left by the LRA 2002. The doctrine was taken further in Thomas v. Clydesdale Bank plc, 2010, where the court recognized not only the wife's presence but also that of her agent as satisfying actual occupation. Extending the concept to agents, however, raises further uncertainty, as it risks detaching occupation from genuine physical presence. Most recently, Baker v. Craggs, 2016, confirmed that courts remain committed to requiring physical presence as the primary indicator of occupation. Yet they also clarified that fleeting presence is insufficient, there must still be permanence and continuity to qualify actual occupation. In conclusion, the LRA 2002 significantly curtailed the ability of adverse possessors to acquire title, particularly in relation to registered land. While the Act introduced stricter procedural hurdles, its failure to define actual occupation left the courts to supply clarity. The resulting case law, Thompson v. Foy, Link Lending, Thomas v. Clydesdale, and Baker v. Craggs, has expanded and nuanced the concept, sometimes controversially. On the one hand, judicial willingness to recognize involuntary absence and continuing intention reflects sensitivity to fairness and the realities of occupation. On the other, these decisions risk undermining the LRA 2002's aim of making land rights certain and easily discoverable. The balance between equity and legal certainty remains unsettled, and actual occupation continues to be a contested and evolving aspect of adverse possession law. Thank you for your interest in this topic, and we are looking forward to seeing you again soon.